the end of 2025, a series of lawsuits were filed by a very, very famous law firm that has been extraordinarily successful in filing fiduciary duty lawsuits in the 401k retirement space. The lawsuits themselves assert that a number of major employers breached their fiduciary duty in the area of a voluntary benefit plan. So here we're talking about ancillary benefits, things like hospital indemnity plans, ancillary plans that really are 100% employee pay-all plans. And the lawsuit said that these employers, and actually their brokers as well, breached their fiduciary duties with respect to how they selected the carriers for these plans and the compensation that they paid to the brokers relative to those plans, by not being prudent in the selection of those carriers and in the compensation paid to the brokers relative to those plans, so that they paid the brokers too much money. Litigation moves very, very slowly, so it's going to be a while before we see what happens. If the 401k sort of history and the history of those cases is any guide, this will take months, if not years, to resolve. That being said, I think what we will see is employers becoming much more aware of their fiduciary duties on the health and welfare side of the world. So one of the major issues asserted in this case is that employers were not thinking about their fiduciary duties and didn't go through the fiduciary process relative to their voluntary benefit plans. So voluntary benefits are kind of interesting relative to their ERISA status. Some voluntary benefits are exempt from ERISA. There's a voluntary benefits exemption for 100% employee pay-all plans, where the employer has very limited involvement and they haven't endorsed that benefit. So there'll be a lot of conversation relative to voluntary benefits as to whether or not a reexamination of voluntary benefits to see if they're even subject to ERISA. So we'll have a lot of conversation about, is my voluntary benefit subject to ERISA? And where they are, we'll see employers really lean into, are we going through an appropriate fiduciary process with respect to my voluntary benefit plans? We'll also see, with respect to non-voluntary benefit plans, medical, dental, vision, sort of the more traditional health and welfare plans, employers begin to re-examine, have we gone through an appropriate fiduciary process? Because, this litigation is a warning sign that we could see more what we call copycat litigation, that this could happen again. And the reason why there's more concern than there may have been even following things like the Johnson & Johnson case and the pharmacy litigation cases that we've seen over the past couple of years is that the plaintiff's attorneys who brought this particular set of cases are the same attorneys who were extraordinarily successful at getting hundreds of millions of dollars in settlements and verdicts in the 401k world on very, very similar claims. Obviously, this news is something that's going to get the attention of employers, brokers, and there are some key takeaways from this. One of them is to reevaluate their voluntary benefit programs, take a look at, are they being treated appropriately as subject to ERISA? Do they need to be looking at their voluntary benefit programs as subject to ERISA? A second key takeaway is to go ahead and take a look across the board relative to health and welfare benefit programs. Are we going through an appropriate fiduciary process? Is there a fiduciary committee in place? Is that fiduciary committee appropriately documenting its process? Are we benchmarking fees? Are we going through an appropriate process of evaluating vendors? Those types of questions. ERISA and its fiduciary duties are not new, but this litigation really does shine a spotlight and serve as a reminder to employers and brokers of the importance of making sure that we are following that process.